Welcome to Behind the Case podcast, a podcast that focuses on navigating the challenges our clients face with divorce and family law in Dallas, Fort Worth, Texas. Behind the Case is brought to you by the Turner-Monahan legal team. With over 70 years of collective experience in divorce and family law. Together, Tyler Monahan, Keaton Monahan, Tina Campbell, and the Turner-Monahan team will discuss real-life cases, answer questions, and explore family law areas from divorce to child custody. Our goal is to clarify scenarios and demystify legal jargon, making the process less daunting and reminding you that you're not alone. So sit back and let's discuss what happens behind the case.
How do courts handle a divorce when both sides refuse to compromise?
A lot of cases start off where neither side seems like they're going to compromise. And a lot of times we as attorneys try to get with our clients and talk to them about attempting to be somewhat amicable with each other, because when it comes time to where the two sides are unable to be amicable or solve problems, the courts get involved, and you're going to go down to the courthouse and the judge is going to make a decision, and you're no longer involved in making decisions about your children and about where they're going to go to school or where they're going to live, what doctor they're going to see, who's going to get child support, what the visitation schedule is going to be, who's going to pay child support, who's going to provide medical support, and how all of your assets and debts are going to be split up. What do you think?
Yeah, I agree. I think the good thing about being able to come to an agreement is that you can be a lot more creative with your life than a court can be, because the court is governed by the Texas Family Code, and there are only certain things they are allowed to do. And so when courts get involved in that decision-making process, their creativity is significantly limited versus when you're able to come to some kind of an agreement.
Yeah, and I think that a lot of people want to go down, maybe even attorneys want to go down and they want to have a big hearing and a big showdown and show their client what they can do. But a lot of times the courts are like, hey, can you go work this out in mediation?
Yes.
Aren't you able to try to figure some of this out on your own? I think being an attorney is not just only advocating blindly for your client's rights, but it's also evaluating the totality of the circumstances to try to formulate a strategy and a plan that's not only best for your client, but what's best for the circumstances for the children and for any property and anything else that might be out there that is a collateral issue in regards to the divorce.
Yeah.
I know we're talking uncontested versus contested divorces a little bit. Kind of explain what those two terms are for anybody that's not familiar with them. And then can an uncontested divorce turn into a contested and vice versa?
Sure. So there's differences that we define contested versus uncontested, or when I say we, attorneys, and here at our firm at Turner-Monahan, I think we look at an uncontested divorce as somebody coming in and saying, hey, listen, we're planning on getting a divorce. We've talked about this for a while. We believe that we have an agreement for most everything. We just need an attorney to help us out. A lot of times we get that, and unfortunately have to say, well, we can only represent one of you. An attorney can't represent both sides, is not able to give both parties advice, but we can provide advice to one of the parties, file for divorce, even get waivers drafted, and have the parties through our client provide us the agreement, and then take a look at the agreement and give some feedback on it and say, hey, look, we think you should do this, this, and this, because this is what we've seen in the past and what we've done in the past. What do you think, McKenzie?
Yeah, I think something that clients get confused about is that they think if they come in with an uncontested divorce versus a contested divorce, that the process is different. And there are differences in the process, but ultimately the process is completely the same. You have to file for divorce still with the same courts, and you have to get them served or sign a waiver of service and enter a final decree of divorce. Ultimately, that is true of both contested and uncontested divorces. The difference lies in how we get there. If it's, oh, we just need to draft up this decree, everyone signs off, it's usually much faster and a lot cheaper for clients. When it becomes contested is when we start talking about not having agreements on certain issues such as the children or, property division, and we either have to have hearings in the court or we have to go to mediation. It makes the process longer, but ultimately it's it ends up being the same. You file for divorce, you serve them, and then you file a decree. And I think some people have this idea that if it's uncontested, we don't have to file a lawsuit, but ultimately it has to be a lawsuit.
Right. And I think when McKenzie mentioned cheaper, I think it's more cost effective for the client, or can be more cost effective for them to get it done amicably, because the more time that we have to spend going down to court, putting documents together, filing things, preparing for hearings, going to have hearings, talking to third parties, gathering evidence, etc., those things may result in the outcome that the party or parties wanted, but may not. You just don't know. So, when uncontested divorces, they aren't always the right thing in every situation, but an uncontested divorce can also look like it's turning contested, but then also become possibly amicable by going to mediation. So uncontested doesn't mean that it has to be a completely full-blown agreement right away, but if you end up having to go to mediation, there could be additional fees. So it's all dependent upon how the parties are able to be amicable with each other. Because the alternative to that is a contested divorce, which contested divorce is when the client contacts you and they want to be the primary parent, or they know that there's going to be issues regarding the children, or immediate issues regarding either infidelity or somebody's wasting assets, or somebody's spending money that they shouldn't be spending. You're filing suit, you're asking for a temporary restraining order, and you're going to court within 14 days. That's a lot of divorces start out that way. I would say the majority of divorces start out that way, because generally you're getting divorced because you're unable to agree and you're unable to be amicable. That doesn't mean that the contested divorce has to end up being contested the entire time. But is that your take on
I
it too?
agree. I think a lot of cases go back and forth between the two. I don't think hardly ever do they start out as one and remain as one throughout the entire process of the divorce. They go back and forth quite a bit.
Yeah, and I think it's very important that when you're looking for an attorney, that you really take into account your attorney's personality and what they're talking to you about in regards to how the process may play out. It's not always best that you think you want the bulldog and you want somebody to fight. I always say lead with the honey and we can bring the stick later. I've never negotiated a deal in my life where I came out swinging and wielding a big club and then forcing somebody into a position where they just submit. That's just not the way that the world works. And it doesn't work that way in court either. And I think if you have an attorney on the front end who's able to provide you with sound advice, you're going to be able to be much more equipped to deal with the ebbs and flows of the divorce process, because it's not quick, it's not easy, and it can be arduous and emotional and grueling, but it doesn't have to be if you have the right navigator to help you navigate these waters, of which we think here at Turner-Monahan, we do a great job of that.
Yeah, and I think having an attorney that has that perspective to be able to direct you and guide you on, I know you're very emotional right now and this seems big, but I want you to look at the bigger picture of the entire case, is really important. And I think we try really hard to help our clients look at the bigger picture and look at the long term. And yes, you might not want to agree with this person right now, but is it best for your children? How is this going to play out in 4 and 5 years versus in this heat of the moment, I am mad at them for something that they did, and maybe justifiably so.
Right. Yep.
So we were talking about contested divorces and how we, are trying to make it amicable, trying to get them to go to mediation. But as they don't go to mediation, how do you prepare for a heavy litigation, and how do judges typically handle having to go to litigation in court trials?
So I think the first step in any heavy litigation is discovery. You have to figure out what is going on by seeing the documents and understanding the position of the other party. And there's lots of ways to do discovery. It's not just necessarily documents. You can also do depositions and stuff. But having a clear understanding of the whole picture is vastly important. It is near impossible to have a heavy litigation case without doing substantial discovery.
Agreed. And discovery is a tool that's used it's used in several cases. A lot of times people may not want to use it because it's more expensive to get discovery going. But discovery is not only used to gather evidence, it's also used to limit evidence. So a lot of times we hear that this person has this or this person has that, or they've got the smoking gun, or the infamous pot of gold at the end of the rainbow, which I've never found to this day, but it's there in almost every case. But it allows you to call somebody's bluff also to get all the facts on the table so everybody knows the playing field. I think that's the most difficult thing in a contested, highly litigious case, is to find out what the playing field is.
Yeah.
Each party has an idea in their mind of what the playing field is. The attorneys try to gather the information, and they can only rely upon their own clients and possibly what the other side will let them know is going on. But it's really hard to determine the playing field. The more effective that attorneys are in establishing the playing field, the better off both parties are, even if it's a highly litigious case. Do you agree?
I totally agree.
And then judges want the playing field. That's why you have discovery. The judges want plenty of time for the parties to have the information, for them to exchange it, for everybody to have inventories and appraisements, for everybody to know what's going on, any of the emails, the photos, the text messages, the police reports, the criminal records, the audio recordings, the video recordings, photos, anything that you're going to use as a part of your case or that you may want to try to limit the other side using. The judge wants everybody to exchange that well in advance. Judges do not want to have a trial within a trial trying to figure out where the playing field is.
Yeah.
Judges appreciate that, and it's essential and imperative that clients make sure that they retain a firm that understands how to set the playing field in a litigious case, and that they can go into court without mumbling and fumbling and bumbling and stumbling over themselves to either try to limit evidence or to try to get into evidence. I think there's a major difference between being able to practice law outside the courtroom and practice law inside the courtroom. And while I'm biased, I think we're able to do a great job of that because we have a really good experienced staff. We have a really good set of attorneys that can go into court and know how to try a case if it needs to be tried.
Yeah, I agree.
So what are some big financial mistakes people make when they're getting into contested divorces or going through a contested divorce?
Let's take a quick pause here. If you or someone you know is navigating divorce or family law matters in the Dallas-Fort Worth area, reach out to Turner-Monahan for a free legal consultation. Call us at 817-332-4477 or visit us at tumolaw.com. That's TUMOLAW.com for a free legal consultation. Now, let's get back to behind the case.
I think when people are going into litigious cases, and when somebody knows that they're going into a litigious case, I mean, there's probably something already going on as to why they would have that belief. And I think that people will try to change the way that they've done things, which I call ordinary course of business or operations, that they're going to take money and move it over here. They're going to take it and do this, and they're going to stop paying this bill. They're going to start doing XYZ. A lot of people will make calculated moves, not because it's just innate in their personality that they're trying to be sneaky. It's because they have fear of the unknown. And I think fear of the unknown causes people to have irrational, emotional, illogical thought processes. So when people may do things that the court would not look at as kosher, or probably and possibly could be violating what an injunction would be, which injunction is what 99% of all judges put into effect in a case to make sure that everybody keeps a status quo. Don't do anything crazy. Don't change your bank accounts. Don't change your emails. Don't go and move around money. Don't change the health insurance, car insurance, etc. I think that people will start to do things because they're just fearful of the unknown.
Yeah.
And so we try to, from the outset, establish the playing field of, look, this is how you need to look at this, and this is what you need to do to make sure that we stay within the confines of what the court's expectations are, because what the court's expectations are probably significantly different than what any client could imagine the expectations would be.
Yes, I definitely agree with that. I think something that people do prior to filing for divorce that sets them up for hardship in divorce is taking on large amounts of debt in their sole name. Even if it's like, say one spouse has bad credit. And so the idea is that, okay, we'll put, this debt in the other spouse's name because they have good credit. But then we have a problem in the divorce because that debt is only in one spouse's name. I would say a large portion of my cases, even though the debt was incurred during the marriage by both parties, often the person whose name the debt is the one who ends up taking responsibility.
Yeah, not to go too far off into the weeds, but along those same lines, if that does occur where one or the other party has most of the debt or majority of the debt in their name, the party thinks, oh, well, the other side's they're just going to be ordered to pay for it.
Yes.
Well, no court order out of the state of Texas, or probably any state for that matter, can interfere with a third party contract. Meaning if you have a credit card and you've run up $15,000 worth of credit card debt, it's in your name. They don't care if it says on that final decree of divorce that if, let's say, it's in the wife's name, they don't care. Meaning the credit card company, the lending facility doesn't care if it said that the wife is ordered to pay it. Ultimately, the person who's on the card is obligated to pay it. And you would have to go sue on the divorce decree, which at the end of the day, yes, you ended up having to pay your credit card debt or you're stuck with it. You go and sue your ex-spouse, you're going to get a judgment from them. And unfortunately, it's worth the paper that it's written on, because what are the chances of you getting blood out of a turnip unless you know that your ex-spouse is extremely wealthy? And more than likely, if that was the case, you're not going to leave with any debt anyways.
Right.
So McKenzie has a great point that people need to be careful about how they put debts in each other's name. We all want to help each other out as a spouse, but you sometimes have to also kind of think about the future and what may happen.
So a couple things like kind of you've mentioned, the attorneys and things like that and going through. One thing is the courts penalize you if you're dragging out your case.
I think it depends on the situation. I think I would say not often, but I can think of scenarios where, courts want cases to move along. Ultimately, if a case does not move along, courts will dismiss it. I don't know necessarily that that's a penalty, and more so just to keep judicial efficiency.
Yeah, I think that, courts have to keep dockets moving.
Yeah.
There's a lot of judicial oversight now because a lot of people, I guess, have complained to the state and legislature and whatever else that things get too backed up. But we've got 3 million people probably live in Tarrant County, I'm guessing, and we have 6 total family courts. So we have 12 judges to take care of, I don't know, let's just say that only 10% of the population is involved in a family matter. That's 300,000 people. There's only 365 days. It's impossible for these courts to be able to handle everything. So they have to clear their dockets with dismissals. But if people want to get divorced, courts want to give them time to get it done. They want it done efficiently. And unless somebody is just intentionally trying not to move forward on proceedings and is causing issues, and a court could then do some sort of sanctions or fines, etc. But that happens in very, very, very rare and seldom cases that I've seen.
A lot of people, of course, want to know, how do you win a contested case? And so what does winning look like for you as attorneys for your clients? And how do you go about making sure that you're going to get the outcome you want?
Well, at the end of the day, there's really no such thing as a win. The win is in the eye of the beholder. So everybody is going to have their view of what a win is. The attorney's view is probably different, or it is different than what the win is for the client, because the attorneys know what goes on in court. And if you look at the family code, it specifically states in there that the court is going to make a just and right division. It doesn't say in there that the court is going to ascertain who they think is a worse person, and when they find that out, they will completely demolish that person and that they will have nothing left in their lives. That's unfortunately for a lot of people a hard reality and a tough pill to swallow. But I also think that a lot of attorneys unfortunately put that concept in their clients' minds for probably alternative reasons and motives. And that starts parties off on the wrong foot. It starts off a relationship on a wrong foot, and the expectations get completely skewed. And I think that the best way to determine what a win is for the client is to start off with reasonable expectations and everybody to understand. So at the end of the day, the expectations, if they're met, that is a win for everybody. Because in divorces, children don't win. There's really no such thing as a win. So the win for the children is the parties somehow leave it up to themselves to be able to make an agreement amicably. And if they can't, when they go into court, they're at least arguing what they believe is in the best interest of the children, or if there's no children, what they believe is the best interest in regards to the division of the property.
Yeah, I think the big thing for me, winning is everyone says no one wins in family law. It's just a hard situation for everybody involved.
Hard measuring stick.
Yes. And I think for me, determining a win is talking to my client about their top priorities in a case, like top 2 or 3 priorities. Like, what are the things that you most want out of this? What is most important to you? And then setting the expectations for them around those things on what the law says, what this judge is apt to do, things like that, to help me know what to focus on and what is important to them. And so I think being able to get things that are our client's top priority, and that might not look the way they expect it to look at first. They might expect it to be, I want to have sole managing conservator, but that's, not the situation in the case. But really their goal is not to have sole managing conservator. Their goal is to make sure their kids are safe.
And that goes back to managing expectations from the outset.
Right.
Yeah.
The last question to wrap up contested divorce is, can you share like an example of a case that you actually had to go through, or just, I know you get a lot of contested, like that's half of your business, right? At least. But is there an example you can give of a case you've wrapped up recently and just kind of what that client was going through and how you're able to help them?
A lot of cases are contested that end up becoming amicably resolved. That doesn't mean they become uncontested. So it's, once you start contesting, it's contested. It never goes back to uncontested. But I think one of the things that we pride ourselves on, I'd say 95 to 97% of our cases settle in mediation or with some sort of amicable agreement. Does that mean we can't try cases? No, because inside of that 95 to 97%, probably 50 to 75% of those end up going to a temporary orders hearing or another hearing on discovery or whatever it might be. You're constantly having things that are trial related. And at the end of the day, not going to trial allows the parties to make a decision for themselves rather than to leave it up to what you would call an unbiased third party who probably heard the same issues the day before and the day before and the day before and the week before and the month before and etc. And they're just like anyone else. Judges are not robots and they're not black and white. They're gray in nature, right? Mm-hmm. Because they are, subjective on how they're going to interpret things. And that's why family law cases and the family code has the broadest discretion for any judge in the entirety of Texas code for legal codes. So it's always what's in the best interest of the child or what's just and right. Well, the best interest of the child is in the eye of the beholder. If you leave it to the judge, that's their decision. Just and right to the judge, or you can decide them for yourself. I've had numerous cases where we thought it was going to go to trial. We were able to settle at the end because of our ability to take the playing field, lay it all out there, have the party take a look at it and say, okay, what's my risk? What's my opportunity cost here of going to trial, notwithstanding any fees as well? Yeah, sure, they take into account what the trial fees are going to be, but they also look at the totality of the circumstances. And for the most part, I think we do a really good job of explaining to our clients what the risks are about going to court, what the rewards could be, what the risks are about making an agreement, and what the rewards are for making an agreement. Everybody has to weigh that. And we do that on a daily basis with our clients. So it's hard to say one case. I think that happens in almost every case. Do you agree?
Yeah. And I think one thing that helps us get there is we are constantly reminding our clients of, these are your goals. Remember when we first started this whole thing, your goal was this. This was the whole point of it. Remember your goals, because I think it's really easy for our clients, especially when we're getting really close to trial and things have really ramped up, to say, I'm already committed to this trial. Let's just have the trial. But if this settlement offer or whatever it is meets your goals, then why put it up to chance with a judge? And I think our ability to really like kind of bring them back down is very helpful in both trial and settlement.
It's risk mitigation. That's what this is. And it's our job as attorneys, or at least we believe here at Turner-Monahan, that it's our job to not only go down the courthouse and fight and pound our fist on the table, et cetera, but our job really is to provide sound advice to our clients so they can move on with their lives if that's what they're wanting to do, and do it in a form where it's under their terms and not under somebody else's terms.
Yeah, I often have to remind my clients, like, you are entitled to a hearing. I am happy to go to a hearing. I love going to hearings. I love being in front of the judge and putting it all out there. But you've told me that these are your goals, and I don't think a hearing will get you the outcome you're thinking it will get you. And so being able to just be honest with your clients about that is very helpful for them, I think.
And that's a good point, that here at our firm, and I know that McKenzie's heard this, and Tina and Heather and everyone else that's been here has heard this, but I'm not going to tell you, and we are not going to tell you what you want to hear.
Right.
We are going to tell you what we believe is the truth, or what we believe the current situation is. We're not going to tell you something just so you retain us, or just so you give us money, or just so we can go to trial and charge more money. That's not what this is about. We're going to tell you where things are. You may not like it, but we're telling you because that's our advice. And that's our stock and trade and what we do.
Yeah.
Thank you for joining us on today's episode of Behind the Case. If this episode offered insight or helped clarify some aspect of divorce and family law, we encourage you to subscribe and share it with others who might benefit. For those in the DFW area that are in need of a legal consultation, you can reach us at tumolaw.com. That's TUMOLAW.com, or 817-332-4477 to schedule a free legal consultation. Remember, the journey through legal matters can be complex, but you don't have to navigate it alone. Until our next discussion, take care. Please note that the information provided in this podcast is for educational purposes only and is not intended as legal advice. Listening to this podcast or contacting our team does not constitute an attorney-client relationship. For advice on your specific situation, please consult with a licensed attorney in your area.